This is Roland Mumford with Mumford.Law. I'm recording this video from a hotel room here in Knoxville, Tennessee, my mobile setup. I'm in East Tennessee because I have 3 days of depositions this coming week representing a state employee who was terminated for reporting illegal conduct, and the state of Tennessee terminated him, and that's our allegations in our lawsuit. So I thought that would be a great topic to do a video about. In most states, there is a state law that has some form of a whistleblower statute. In many states, though, that whistleblower statute may apply to employees that work for both private employers and governmental entities, which would be city, county, and state governments, and all kinds of departments that fall under those governmental entities. Now, the other extreme is that there may be a state statute that only allows whistleblower protection for government employees. So I'm going to use the example of Tennessee and Georgia because those are states that I litigate in, but also they're on the far extremes of protection for whistleblowers, and many states are going to fall somewhere in between. So in Tennessee, we have the Tennessee Public Protection Act, the TPPA, and it allows protection for private or government employees that refuse to participate in illegal activity or were terminated for reporting illegal activity. But it's not just illegal activity. It's also violations of regulations or public policy. And if a person is terminated for blowing the whistle about the acts of another employee, then they can file a lawsuit and they can seek back pay, front pay, and attorney's fees and costs. It is a very broad and encompassing statute that employees can take advantage of and are protected under. But under the Tennessee Public Protection Act, a few years ago, they changed the causation standard, which is the evidentiary standard, from a substantial motivating factor to a sole cause standard. What that means is that in the previous language of the statute was that if you were terminated for blowing the whistle and the employer came and said, well, we may have terminated him for blowing the whistle, but over here he came into work late one day, you could still proceed with your claim, because if you can show that the substantial motivating factor on the part of the employer to terminate your employment was retaliation for you blowing the whistle, you could proceed forward. Unfortunately, now what they have done is they've raised it to a sole cause standard. What that means now is if that employer can literally admit, okay, well, we may have fired him in retaliation for blowing the whistle, but he was late one day and we also considered that as a factor in terminating him, then you will not be able to proceed with your case. In many other states, there's going to be varying evidentiary standards, whether it be substantial motivating factor or maybe clear and convincing, or it may be a sole causation factor. It just really depends. In Georgia, there's the Georgia Whistleblower Act. That only applies to government employees, whether you're a police officer or you're a city clerk for a city government, or you work, you're a sheriff's deputy, or you work in the county clerk's office, all the way up to state employees. I get many calls from citizens in Georgia that were upset that they blew the whistle on illegal conduct on the part of another employee, and they don't know that it only applies to government employees. Now, there are all kinds of whistleblower laws under federal statutory schemes. And one common type of claim is under the False Claims Act. And an example of that would be, let's say you're a nurse, you work in a hospital, and you learn about fraudulent billing practices by a medical provider or the hospital, where they're submitting multiple claims of treatment, maybe when in fact there was only one treatment. And they're trying to double dip or triple dip and get the federal government to pay them for multiple treatments when in fact it was just one treatment. There's all kinds of examples of fraudulent billing practices that could fall under that example. There are all types of government contractors that would fall under the False Claims Act also. Now, it is possible that in some cases, if you work for a private company and they are a contractor for the federal government or a state government, you may fall under the statutory scheme where it only protects government employees. If you're working for a vendor and they're contracted with a state or federal government, then your state whistleblower law may protect you. Thank you very much for your time. We're very close to reaching 10,000 subscribers. Please click like, share, and subscribe and help me get to that goal by July 31st. Have a great day.